This, as you probably know, Constitution Day has been mandated by Congress for all institutions to receive federal funding. As much as I'm opposed to federal mandates, this gives us a great opportunity because Constitution Day is a reminder that, as Tocqueville said, in the United States, to paraphrase Tocqueville rather, almost every political issue eventually becomes a constitutional one. It's a remarkable feature of American politics, to which constitutional debate surrounds so many important issues. And never have we had a clearer example of this than the current debate over the treatment of enemy combatants that are being held in Guantanamo and elsewhere. The current legislation that some of you might have gone to Senator McCain's talk last week, the legislation that he is intimately involved in on the treatment of prisoners, was a result of a decision by the Supreme Court, Hamdan versus Rumsfeld last June. And what we're going to try to do today is to talk not just about that decision, but to talk about the broader issues raised by it. And as you'll see from the discussion, there are innumerable constitutional and policy issues that have arisen from this. The extent of presidential power, the role of the courts in foreign and defense policy, the status of international law, and most obviously, the treatment of prisoners and the nature of human rights. Now, it's very tempting to view these as simple moral issues. But I think one thing you will come away from today is to find out these issues are actually more complicated than you would ever imagine. The court decision that we're talking about is about 200 pages in total? 180 pages. The legislation that is being proposed is about 90 pages. And I just want to really thank the panel members because they have really done an awful lot of work trying to figure out what this decision means, what some of the broader issues are, and doing it in a way that's understandable to a general audience. So in advance, I'd like to thank them. Let me introduce the panelists and then talk about the order in which they'll speak. George Brown will be our first speaker. Is a Robert Dryden Professor at the Boston College Law School. Until last year, he was the Associate Dean of the Law School, and he's written frequently really wonderful articles on both federalism and on ethics in government. Dan Canstrom is a director of the Boston College Law School International Human Rights Program, clinical professor at the law school, has written extensively on immigration and refugees, and has a book coming out soon on refugee policy? Deportation. Tim Crawford is a professor in the Politics and Political Science Department, is our newest IR hotshot and the author of Pivotal Deterrence. Mark Landy is professor in the Political Science Department, an expert on the presidency and American political development, the author with Sid Milkus of Presidential Greatness. So as you can see from the cast of characters, this is really an effort for people from the law school and the political science department to get together and share their wisdom and learn from each other. And I hope this will be an indication of very close connection between law and politics in American politics. George.
Well, thanks very much, Shep. Hamdan, the actual name of the case, Hamdan v. Rumsfeld, and yes, it is that Rumsfeld, it's one of those cases that almost inevitably gives rise to great rhetorical flourishes. And I wouldn't be surprised if we heard one or two of those flourishes this afternoon. I don't get to give any because my somewhat prosaic job is to state the case, to try to explain what happened and what happened in the court. That's not an easy job because, A, it's a complicated case, B, only 8 of the 9 justices participated, and C, they authored 6 opinions. I'll try as much as anything to guide you through it and decipher. And in the process, I'm going to have to omit a little bit, but I know from talking with my fellow panelists that they'll fill in some of the things that I omitted. And if at times my remarks seem a little technical, a little legalistic, that is intentional, because in the words of Justice Kennedy, and as you'll see shortly, he plays a very crucial role, quote, "A case that may be of extraordinary importance is resolved by ordinary rules." And in a minute I'll get to what those rules are, but first let's talk a little bit about what happened, as the facts, as we would say in first year of law school. Salim Ahmed Hamdan is of Yemeni origin. In 2001, he was captured in Afghanistan. In 2002, he was transferred to Guantanamo. In 2003, the president deemed him eligible for trial by military commission. In 2004, he was charged with conspiracy to commit offenses triable by military commission. Hamdan seems to have been an interesting player. It is alleged that he served part of the time as Osama bin Laden's bodyguard, that he transferred weapons among various members of al-Qaeda, and that he received al-Qaeda training. So here he is, he's been charged, and he brings an action for habeas corpus and other relief, basically aimed at stopping the trial, his trial that is scheduled to occur before a military commission, not a court martial of the sort you're used to seeing on JAG, but a somewhat different entity that I'll get into in a moment called a military commission. The trial court, the district court, granted his petition for habeas corpus and stayed the proceedings. The Court of Appeals for the District of Columbia Circuit reversed, and that's particularly interesting because one of the 3 judges on the panel was then Circuit Judge Roberts, now Chief Justice Roberts, who did not participate in the Hamdan decision, hence the 8 instead of 9 justices. There are some important issues at the Supreme Court level that I won't address, not because they're not important, but because I simply don't have the time. One is whether Congress had barred the federal courts from, or at least the federal district courts, from exercising jurisdiction over a case like this, and whether that would pose questions of suspending the writ of habeas corpus. A second is whether the offense alleged was actually triable. What does it mean to conspire to commit offenses triable by military commission? That might sound a little vague. And the third was whether the federal court should have heard the case at all, or whether they might well have abstained the various doctrines. But I'm going to focus on the military commissions and what the court held and said about their validity. How do they work? Well, they were established by presidential order, supplemented by orders from the Secretary of Defense. There's a presiding officer, at least 3 members. He rules on, he's sort of the trial judge, or she. They function somewhat as a jury. The accused is entitled to military counsel and can, if he or she can pay for it, hire civilian counsel, provided that they have a certain level of security clearance. The accused is entitled to a copy of the charges in English in his or her own language. The presumption of innocence applies. Proof beyond a reasonable doubt is necessary. This is from the government's brief, but I don't sense much disagreement with it. And normally, the accused gets to confront the witnesses, and normally would get to subpoena his own witnesses, and there would be review of the decision at various administrative levels and ultimately by courts. And the commissions have been seen as posing 4 very serious problems. The best known is the possibility that the defendant could be denied the right to be present, denied the right to see the evidence against him. Less known, but of great importance to Justice Kennedy, is the appointing authority and the powers of the appointing authority, whether the appointing authority has too much power. A third problem that is frequently cited with the commissions is that the evidence need only pass a relatively low threshold of probative value, much lower threshold than the standards we use for admitting evidence in federal trial courts. Hearsay, for example, evidence obtained through questionable means of interrogation, all that would be admissible. And sort of in the background of the case is, what is the law that governs this challenge by Hamdan to the military commissions? Is it United States law? If so, is it a statute or one or more statutes? Is it the Constitution? Or, hovering not so far in the background, is it international law that tells us whether or not we, the United States, can try people like this? Let me first talk about Justice. There are several opinions I'm not going to talk about, but I'll focus on Justice Stevens and Justice Thomas. And Justice Stevens said, well, we really need to look at the statutory underpinning of all of this. Congress has played a large role in setting up the military system of justice. And with respect to military commissions, the Congress has said that the provisions of the Articles of War shall not be construed as depriving military commissions of their normal jurisdiction. So clearly they've been around for a while, and Congress is aware of it and has sanctioned them to some extent. But what Justice Stevens focused on was what he called the uniformity principle, the notion that as near as possible, the procedures in front of military commissions should be the same as the procedures in front of courts martial. And he found a number of deviations from this principle of uniformity, notably the right to be present, the right to know the evidence against one, and the somewhat more lenient rules of evidence that it would apply in the military commissions. So Justice Stevens had little problem in concluding that the president had gone beyond domestic statutory law as established by Congress in the way that he and the Secretary of Defense set up the military commissions, and therefore, of course, if the commissions are invalid, Hamdan can't be tried. But Justice Stevens didn't stop there. He went on to note that the commissions deal in part with offenses under the law of war. The law of war. I don't think we teach that in law school, although maybe we will, but it's definitely out there, and said Justice Stevens, it includes international law, and in particular, it includes the Geneva Convention, and this is the last quote I'm going to give, some language in the Geneva Convention that says sentences can only be passed out by, quote, a regularly constituted court affording all the judicial guarantees which are recognized as indispensable by civilized peoples. So that's a rather broad standard. And Justice Stevens said, well, as a starter, it requires, when it says regularly constituted, that the tribunals that try people operate under the normal rules of the normal courts. And in our system, the normal military courts are the courts martial. And so therefore, he was able to reinforce his statutory conclusion by saying that military commissions have got to act like courts martial unless it can be shown that there's some strong practical need for departing from the court martial norm. And that is the core of the Stevens opinion, and he was joined by 4 justices, so that's the opinion of the court. Justice Kennedy went on to find some other things wrong. Well, Justice Stevens found that the lack of presence of the accused under certain circumstances would violate the Geneva Convention. Justice Kennedy focused on the composition of the military commissions and what he thought was too much command influence. And if questions permit, I'll get into this further. Let me, in the interest of time, move directly to Justice Thomas. There were, after all, 3 dissents, and I think we can figure that Chief Justice Roberts would have been on the same side at the Supreme Court level as he was at the Circuit Court level. So that we're looking at essentially a 5-4 split with Justice Kennedy somewhere in the middle. And Justice Thomas is particularly interesting for 3 or 4 reasons. First of all, he emphasizes the powers of the president. The powers of the president as commander-in-chief, the powers of the president in times of war. And Justice Thomas is a very strong exponent of vigorous presidential power. Secondly, he argued that Congress had authorized the president to do what he did. That yes, there were these older statutes that talked about how procedure in military tribunals was supposed to be uniform to the extent possible, but more importantly, right after September 11th, Congress had passed the authorization for the use of military force that authorized the president to take all necessary measures to deal with the attack of September 11th, to use force, hence the title, Authorization for the Use of Military Force, and to prevent such attacks from happening in the future. So far from seeing this as a case where Congress and the president were potentially at loggerheads, Thomas saw this as a case where Congress had given the president authority and the president had taken it and run with it. Thirdly, Justice Thomas several times repeats and emphasizes his view that the courts aren't competent to judge this sort of thing. They're not experts in military matters. And how we try people captured on the field of battle, and whether we use military tribunals, whether we use military commissions, whether we use courts martial, whether we refer them into the regular court system, those are matters of military judgment in Justice Thomas's view. Lastly, and I think in some ways this is, and I'll close on this, this is the most provocative aspect of the Thomas opinion. He, more than anyone else, distinguishes the problems that we face in the war on terror from conventional warfare and from other problems that the military has faced in the past. And he's quite eloquent in his argument that we need to recognize the so-called new paradigm of the war on terror, and that we shouldn't freeze, to use his verbiage, we shouldn't freeze the president in the precedents and rulings of the past. So there you have it. That's just a quick slice at 3 opinions, the net result of which is, over some strong disagreement and objection, the military commissions were struck down. Now, it may sound like I don't think Hamdan is a big deal. Is it a constitutional decision? No, I don't think it is. There's some mention of the Constitution. Does it hold that international law is there as an absolute binding, guiding principle on the United States government? I don't think it holds that either. Is Congress now free to reconstitute the military commissions the way President Bush originally set them up? I think it's pretty clear from the decision that it is. On the other hand, from a doctrinal view, it's an important separation of powers decision. And more than that, it shows us the courts in their traditional role acting as the organs of sober second thought in the community. Thank you.
Well, I just want to begin by saying that I agree with pretty much everything that George Brown just said, and I'm going to say similar things, although I probably will succumb to the rhetorical flourish problem every once in a while. The Supreme Court's Hamdan decision has been described by many leading constitutional scholars, most particularly Walter Dellinger, who I read recently, as one of the most important Supreme cases ever decided because of its separation of powers implications. And this, I think, is true. But I'm not going to talk about that. I want to talk about 2 other aspects of the case that I think are at least as important, and those are basic human rights and the relationship between international law and the law of the United States. I think, in the long run, that these will be seen to be at least as significant. First, about rights. Mr. Hamdan, who might have been Osama bin Laden's driver and might not have been. We don't know for sure. And if you think that that's just speculation about what we don't know, you should maybe take a good look at the cases of Jose Padilla and Yasser Hamdi, U.S. citizens who were designated unlawful combatants, against whom the allegations have moved quite substantially from the time they were arrested to now. In fact, Hamdi was released recently. Anyway, he might have been, and he might not have been. But in any case, here's what we know. He was facing a proceeding in which he was at first deemed eligible for trial by the president before a military commission for then unspecified crimes. Then the crime was specified, and it was called conspiracy, a freestanding offense of conspiracy, that is, not murder, attempted murder, accomplice to murder. In other words, not for actually having done anything. I'll come back to this problem in a minute. He faced a possible penalty of 10 years in prison. And by the way, that does not mean that he could not be held as an enemy combatant beyond that time, but that's also a different issue. Others in the military commission system could face the death penalty. So Hamdan's case and the issues raised by it were important beyond the 10 years that he faced. According to the rules of the commission trying him, Hamdan and others like him can be, and Hamdan was, excluded from his own trial. They can be barred from even seeing or knowing about the evidence used against them, and their lawyers can be barred from even discussing it, if the lawyers are shown excerpted versions in camera, that is, behind the scenes. Evidence obtained without a warrant may be used, as may evidence obtained through coercive interrogation methods, that's a euphemism, that would clearly be impermissible under the Fifth Amendment in United States courts. That's basically what we're talking about in terms of rights, some of the most basic core civil rights that we know. Now, what about international law? Here's how an amicus brief by international law experts reacted to the decision below by the D.C. Circuit Court of Appeals, in which Justice Roberts had joined. Quote, "The ruling below would permit trials by military commissions utilizing procedures that are ad hoc, obsolete, and contrary to modern international norms for fair trial of persons captured in war. Reversal is vital to avoid dilution of hard-won international standards for due process of law," end quote. Among the problems noted by these scholars were norms that require courts or tribunals to be independent and impartial, that require non-discrimination against foreign nationals. That is, if you capture a citizen, you have to treat them the same as a non-citizen. And that in the past has happened in this country, by the way, with some Nazi cases that I'll talk about in a minute. The norms require presence at trial and require the right to confront evidence. All of these norms are guaranteed by more international conventions than I can name or count for you here, most prominently the ICCPR, the International Covenant on Civil and Political Rights, to which the United States is a party, and many of them are non-derogable even under conditions of war or emergency. That means they are fundamental, they can't be taken away. They're among the most fundamental rights that we know. A group of 422 UK and European parliamentarians, including 13 former judges of the UK's highest court, former cabinet ministers, a former attorney general, and the former Archbishop of Canterbury, submitted an amicus brief. By the way, nearly 60 amicus briefs were filed in this case, meaning the court had a lot of friends, or people who wanted to be friends of the court. Anyway, this group wanted to draw the court's attention to what they called, quote, "the common heritage of respect for human rights and the rule of law of civilized nations," unquote. Another way to put this, as I do sometimes in my classes, is to say Nazis were not chopped liver. We have seen danger in the world before, and there's a long tradition of grappling with these things, the Geneva Conventions being the outcome of the last great confrontation with these questions. And so it's not quite as new as some would say. So they were talking about a common heritage of respect for human rights. And they noted that the United States has long been a leading proponent of these principles, which are reflected not only in the Geneva Conventions, but also in human rights treaties and norms of customary international law. They cited two cases that had recently been decided in the United Kingdom, which I would recommend that you read, that dealt with the rights for terrorism-related prisoners in Belmarsh Prison, and that rejected the use of evidence obtained by torture in judicial proceedings in the United Kingdom. That's called A v. Secretary of State and X versus Secretary of State. You can find them easily online. In any case, the most specific issue before the Supreme Court in this realm was the 1949 Geneva Conventions, and two problems arose with that. First, are the Geneva Conventions judicially enforceable in U.S. courts? And second, if they are enforceable, do they protect the rights that Hamdan claimed were violated? So first, about enforceability. The appeals court, in Justice Roberts, the opinion that Justice Roberts joined, held that they were not enforceable. Now, this might strike the non-specialist as odd, but it's not odd. In fact, it's a well-accepted aspect of the U.S. approach to international law, which is a rather, specific approach. U.S. courts might recognize that a valid treaty exists, that it was signed by the President, that it was ratified by the Senate, and that it applies to the issues in the case, but then courts may hold that it does an individual no good. It's not enforceable in U.S. courts. This is why it's so important that the Torture Convention, for example, is accompanied by a statute that provides rights in U.S. courts against torture. We can talk more about this if you want when there are questions. But the appeals court was wrong about the Geneva Conventions, held the Supreme Court, because, and bear with me, it gets a little complicated, but basically the idea was the Geneva Conventions are part of the law of war. And the law of war is complicated. In a moral sense, it seems an oxymoron. I mean, how can you have a law of how to kill people? But there is a law of war. There's a long tradition of this. And you can distinguish the law of war from the law against war. There are Latin formulations for this. We're talking about the rules of conduct in war. If you do have a war, there are ways you do it, and if you do it the wrong way, it's called a war crime. So the Geneva Conventions are part of that, and that matters because the court held that the Commission's basic authority derived not from the authorization for the use of military force, as George pointed out, or from any other statute, or from inherent presidential power, which some have argued, but from the Uniform Code of Military Justice, and that compliance with the law of war is the condition upon which that authority is based. So there's a link between the separation of powers questions, the Code of Military Justice, and the history of the law of war and the Geneva Conventions. So the conventions were held to apply, and this was a big difference between the D.C. Circuit Court case and the Supreme Court case. But do they protect Hamdan? The appeals court held, even if they apply, they don't protect him. Again, I and many others thought this was incorrect, and the court sided with that view. The issue was that Al-Qaeda is not a nation state, and obviously not a signatory to the Geneva Conventions, and that's a problem for a lot of different reasons in the convention. The conflict with Al-Qaeda is different from that with Afghanistan, for example. But the Supreme Court held that Common Article 3 of the conventions, which applies to combat, quote, not of an international character, protected people like Hamdan. That not of an international character doesn't mean a civil war. It means not of a character of a conflict between two signatories. That was basically the ruling on that point. And Common Article 3 prohibits the passing of sentences without previous judgment by a regularly constituted court affording all the judicial guarantees recognized as indispensable by civilized peoples, end quote. The court held that this means that a military commission must follow regular laws and procedures already in force in a country, which the Bush commissions did not. Finally, about conspiracy. 4 justices concurred on the point that conspiracy, as a freestanding charge, is not an offense under the law of war that may be tried by a military commission. This follows a general approach taken among international tribunals, including the Yugoslavia Tribunal, the International Criminal Court, and others that see conspiracy charge as a rather odd Anglo-Saxon invention. As Neil Katyal put it in oral argument, quote, under the government's theory, even a little old lady in Switzerland who donates money to Al-Qaeda, pause and picture that for a moment, I did, to continue, might be swept up within this broad definition of conspiracy, end quote. He meant to a front organization. The little old lady gives money innocently. That could be conspiracy, he says. This rule, by the way, was also true at Nuremberg. The Nuremberg Tribunal rejected conspiracy charges. The idea was that people should be tried for what they have done, not what they might want to do, though if they aid or abet a war crime, of course, they are guilty of that offense. That's well accepted. The 4 concurring justices also held that Common Article 3 also embodies trial protections accepted by, quote, customary international law, unquote, which would expand the rights in quite important ways. Justice Kennedy felt that it wasn't necessary to get to that issue, and so we don't know whether there's a court majority for that proposition or not. But I think there may well be 5 justices who believe this. The Geneva Conventions are enforceable in U.S. courts. They apply to people like Hamdan, non-citizens designated by the executive for trial. They embody significant procedural protections, and maybe we can look to international human rights law, treaty-based or customary, to determine the content of those rights. Now, as George said, it's quite possible that the Congress can trump all of this with a well-crafted statute, which is exactly what it's working on now. But I doubt it. I think that the Geneva Conventions and human rights law are now inextricably linked to these issues and to the Guantanamo detainees, and that's all to the good. And the debate in the Congress, I think, illustrates that. Why is that? I think here we see the power of 3 related ideas: reciprocity, equal protection of laws, and precedent. The President's first military commission order, September 13th, 2001, right after the attacks, focused on non-citizens only. Why did he do that? Franklin Roosevelt hadn't done that. His order applied to anyone who sided with the Nazis. And in fact, as I said, U.S. citizens were tried by commissions, and that was upheld in the Quirin case. But this administration focused only on non-citizens, and maybe in questions we can talk about why that was. But the conventions, like all of human rights law, are reciprocal and universal. They are primarily human rights, not citizens' rights. These are important leitmotifs in the current debate over torture. The President says that what he seeks is clarity about what is torture. But the approach of international law has been to aim for such clarity as can be achieved, but to recognize that language and human imagination are limited. So international law uses a pragmatic, if you will, a neo-Kantian or a Rawlsian mechanism to supplement clarity, and that's reciprocity. Define torture as you want it defined against you if the tables were turned. Then the definition protects everybody equally. As Justice Breyer put it in oral argument, quote, "If the President can do this, well, then he can set up commissions to go to Toledo, and in Toledo pick up an alien, and not have any trial at all except before that special commission," end quote. That was during the oral argument of the Hamdan case. And in what I think was an important concession that may have differed from the position of some in the administration, Paul Clement admitted, quote, "This is a war where the laws of war are involved," end quote, during the oral argument. But he had earlier said that the Geneva Conventions don't apply, to which Justices Souter and Kennedy were skeptical that he could have it both ways, and the court's opinion held that he couldn't have it both ways. Neil Katyal, in his argument before the court, concluded with this quotation from Thomas Paine, quote, "He that would make his own liberty secure must guard even his enemy from oppression. For if he violates that duty, he establishes a precedent that will reach unto himself," end quote. It was Justice Stevens, later to be the author of the majority opinion, who then simply said words that I would echo in conclusion. "Thank you, counsel," end quote.
First, I just have to ask, where was George Brown when I needed him, when I was plowing through 180 of some of the most turgid pages ever conceived, and George Brown understood the whole thing. I could have done this in 5 minutes. I agree with both Dan and George that this is a case largely, and I'm not going to get into some of the international ramifications that Dan got into. It's essentially a case about separation of powers and checks and balances. And like any really profound idea, it seems to me we have to recognize that checks and balances and separation of powers are not ideas to be applied dogmatically and thoughtlessly. There's some responsibility on the part of all of the 3 branches of thinking a little bit about what pertains to the other branches, or even a lot. We expect presidents and legislators to worry about the constitutionality of what they're doing. That's not an issue they should relegate to the courts. Often that's the end result, but not as a matter of sort of lack of conscientious thinking on their part. And after plowing through the 180 turgid pages of this decision, what I found most disheartening was the inability of the majority to really think like an executive. They couldn't think about the problem that the country faces for which the executive is responsible, because the nature of executive power, even whether you take the most extreme version of a Clarence Thomas or a John Yoo, or a much more modest version, in times of war, particularly, the executive has some kind of prerogative. He has some powerful responsibility for fulfilling his oath, which is to preserve and protect the Constitution. And you can read the 130 or 40 or so pages of the majority opinion and never get a sense of that. Never get a feel for what it is like to fight a war, and particularly a war that has to be fought under very extraordinary, trying, and difficult circumstances. So to me, that the unrealism of not so much of the decision, because oddly enough, as I follow the congressional deliberations over the last few weeks, it looks to me like it's going to be a pretty decent law that's going to emerge. A law so decent that Dan would probably find it unconstitutional, yeah, indeed. And it's especially important for this necessity for judges to think at least a little bit like executives, because we're dealing here with the grayest of all gray areas of the law. Presidential emergency powers exercised under times of war. I was taken back to, in my thinking, to the very first such conflict in American history, which was the enormous dispute over Washington's neutrality proclamation. The president does not, in the Constitution, have the power to declare war. That's Congress's power. How dare he declare peace? That's what Washington did in the neutrality proclamation. He announced that despite treaty obligations to France, the United States was not going to side with France in the war against Great Britain. And it's very hard to read the letter of the Constitution and find any justification for that action other than the most obvious and deepest justification, which is it was what the country had to do to survive. That's the only serious justification for the neutrality proclamation. We had a choice of siding with the land power, namely France, against the world's great naval power, namely Britain. Land powers couldn't do us in because we had this marvelous ocean between us. Naval powers could and perhaps would have. We'll never know. So despite the continual reference made to the law of war in the decision, and by my esteemed colleague, I find the whole notion of the law of war a much more ambiguous, difficult, and uncertain premise upon which to build this case or any other particularly difficult case. And the law of war and wars have become ever more unlawful. And therefore, it seems to me it's ever more problematic to make reference to it. I draw your attention not even to the most egregious cases. Let's just start with the saturation bombing of Kosovo by us. If this is lawful, this is the lawful use of force. If this is something you want to build laws around, I find it very difficult, even though I wouldn't necessarily disagree with the decision to saturation bomb Kosovo. And Dan, the Dans and the Dans. Dan reminds us that the Nazis were not chopped liver. I would say they were not chopped liver, but the Nazis had a tremendously prudential concern for obeying certain rules of war, because they had uniformed soldiers. Their soldiers were going to get captured by us. Let me remind you of the things that Al-Qaeda does, that Hezbollah and Hamas do, that the Nazis did not do. They did not use human shields. They did not use suicide bombing. They did not indiscriminately bomb mosques. They did not engage in the just routine violation of any humane idea related to war, which is at the heart of what terrorism and many forms of guerrilla warfare are about. The whole idea of this kind of warfare is a certain kind of jujitsu. You use your very weakness as a form of strength, right? So you put 10-year-old children in front of you, and you dare the enemy to kill the children. This is as unlawful as any kind of activity humanly imaginable, and you have to recognize that if you are fighting under those conditions, you are being put under terrible kinds of pressures. And before you get to questions of limitation and juridical issues, you have to decide what is necessity, what must happen. In the more than 130 or 40 pages of the majority decision, there are only one, although military necessity is cited as the key question, there is no discussion of military necessity. It's as if Stevens and Kennedy, who wrote the long decisions, really they haven't thought about military necessity, and therefore they haven't lived up to their responsibility as justices. What is the nature of this animal, this beast called the terror, such that you would try to create some sort of adjudication, some sort of justice process to deal with it? There's no effort, for example, to confront the executive's argument for the tribunal, based on what I take to be a very serious effort to balance justice and military necessity. The basic justification offered by Rumsfeld, I read this in a press briefing of his, is that there needs to be some means of bringing people to justice during war, because the war on terror is ongoing. Right? One of the terrible justice problems that the war on terror raises is if you just detain terrorists or accused terrorists on the grounds that you can't really try them in a proper way until the war is over, we're all going to wait a very long time. And there's a real naivete in Kennedy and in Stevens, both of whom say, well, we kept Hamdan for 4 years, why couldn't we just keep him longer? This struck me as the most antithetical to justice statement I read in the whole case, right? I mean, this is a terrible idea to just detain people forever. So the real question is, how could you, given the exigencies of this kind of war, under these kinds of terrible circumstances, how can you do the best you can? Not what would you do if there were all kinds of decent circumstances surrounding the case. If you could allow the accused to confront their accusers. That's a very good idea. We favor that under all sorts of circumstances. But here we know their accusers are basically intelligence people working for us. The last thing in the world I think any of us want to do, if we really think about it, is allow these people to confront their accusers, because then these accusers are dead. Likewise, notions about evidence that we all hold dear, and particularly hearsay, which is a particularly ugly form of evidence. This is a lovely thought. But under these circumstances, garnering intelligence in the process of trying to fight a terror war, there isn't going to be this kind of evidence. It's not going to exist. So again, the choices are much more stark in most of these circumstances. Either drop the charges because the evidence is insupportable, it's not good enough by civilian or even ordinary court-martial standards, or simply indefinitely detain these people. It seems to me these are very ugly choices, and the military tribunals are actually a way to improve on those choices. The military tribunals may or may not be the best you can do under the circumstances, but what strikes me about the judges is they don't ask the question. They don't try to press this question of what is it that we could actually live with under this terrible sword of Damocles of a terror war. And I would go so far as to say there's a sort of willful denial that the war on terror is a serious business. And I have to say this applies to this discussion that Dan does raise about conspiracy. Can you try conspiracy as a war crime? Well, you know, here's what Hamdan is accused of. He says we don't know if it's true, but that's because the trial couldn't occur, so there was no possibility of knowing if it's true or not. But Hamdan is accused of not only being the driver for bin Laden, but transporting military equipment, helping organize supplies, participating in all sorts of logistical enterprises relating to al-Qaeda. He joined al-Qaeda after al-Qaeda had already bombed the World Trade Center, the Khobar Towers, the USS Cole. It had declared war on the United States. So there's no question of his knowledge of what he was engaged in. And there has been no evidence presented, because the trial couldn't take place, claiming that he wasn't really a member of al-Qaeda. So it seems to me that there is a real charge here. It's not specious, and it's not superficial, and it's not airy-fairy, and Hamdan is not a Swiss old lady. So he goes on, for example, to say another reason you can't have this trial is because the war hadn't started yet. Like a lawyer, I think, or in this case, a bad lawyer, Kennedy says the war starts when the authorization to use military force is passed. And Hamdan had been, I guess, already arrested by then, because, or at least the crimes that he's charged with took place before that, so the charge is not adequate. I mean, from an executive point of view, this is insane. A war starts when you're attacked. That's when a war starts. You could argue it started in 1993 with the al-Qaeda bombing of the World Trade Center. You could argue it started in 1996 when al-Qaeda declared jihad against the US. You could argue it started in 1996 again with the bombing of the Khobar Towers in Saudi Arabia, or, you know, 98, the bombing of the embassies in Kenya and Tanzania. 2000, the bombing of Cole, of the USS Cole. So this strikes me as lawyer think, which is particularly destructive in these circumstances. Okay. We have, and having said all this, I don't want you to think that I am authorizing some sort of carte blanche for the executive. Quite the contrary. I'm trying to figure out, how do we think through appropriate executive behavior in these circumstances, given the realities? That's the problem. And if you go back over the great cases of executive prerogative being exercised in the United States, I think you see a very mixed picture, and therefore you can really exert some serious thinking and critical judgment. You go back to Lincoln's suspension of habeas corpus, right? He suspended it in Baltimore because Baltimore was both the incredibly important entrepot for U.S. troops and materiel going to fight the Confederates, and it was also the northern gateway to Washington, D.C., and it was full of spies and Confederate sympathizers who were going to do all kinds of acts of terror in Baltimore if they could get away with it. So it seems to me you look at Lincoln's use of the prerogative, and it's defensible. On the other hand, you look at the president, who I was a little surprised to hear Dan be so positive about, Franklin Delano Roosevelt, who incarcerated American citizens under the thinnest racist pretense. The single most indefensible decision by an American president, the most indefensible use of the prerogative that I'm aware of. And you look at it, and you look at it, and you look at it, and you learn that his intelligence officers told him it was not useful. You learn that most of his key advisors explained to him that it had no war purpose at all, and he did it anyway. Right? This is a case for censure. This is a case for saying the executive prerogative has gone too far. Or you look at Truman's seizure of the steel mills, which the Supreme Court turned down. And again, it seems to me Truman went too far. Truman had perfect legal authority for for keeping the steel mills in operation. He didn't want to use it because he'd promised labor he wouldn't enforce the Taft-Hartley law. Sorry, Harry, that's not good enough. Right? So what I see in this kind of reasoning, this kind of almost ostentatious refusal to consider the actual circumstance of a country at war, fighting the most impossible war, all right? A war with no boundaries, a war where the other side wears no uniforms and has no home base. I find that to be my deepest criticism, and I hope that the justices learn to think that way. We need them to do so. Thank you.